Court is resumed. Please be seated.
Before the break, the court asked a little bit about Indian monies, and I kind of want to square the circle for just a moment. None of the parties argues that the monies are Indian, annuities are Indian monies. And as a result, I don't believe anyone spent much time on the subject, but I am aware of, and I'd like to, if the court wants to look at it, there's the case of Beattie versus Canada, BEATTIE, V period Canada, 2005, FC 715, where at paragraph 32, quoting from now Justice Lafreniere, who was then prothonotary, at paragraph 32 of the Federal Court Trial Division decision, the separate references to Indian monies and personal property given to Indians under treaty in Section 90 of the Indian Act suggest that Parliament did not intend the term Indian monies to refer to treaty monies. If it had so intended, there would be no reason for Parliament to separately refer in Section 90 to property given under a treaty. As a result, there is no support for the proposition that annuity payments constitute Indian monies pursuant to the Indian Act. And Indian monies are, in fact, as I indicated, defined. If you want to look at it, I'm not encouraging you to, that you need to, but it is defined in the Indian Act as in effect, monies held in trust by the Crown.
Thank you.
So, turning to the topic of the treaty promise to share is different than the losses caused by the breach of treaty. Both crowns treat, whether it's compensation or whether it's called damages, as being limited to some share of the portion of the resource rents that the crowns actually captured directly in the past. Put another way, the crowns argue that compensation can only include some amount for a portion of what the Crown did collect directly. Now, not only do we say that the plaintiffs are entitled to a share of what the Crown actually collected, both directly and indirectly, we say that the plaintiffs are entitled to all losses caused by the breach. And the breach, we must remember, is twofold: failing to engage in a process to identify the net Crown resource related revenues to be shared, and failing to pay the augmentation when due in accordance with the law. The law being diligent and purposeful fulfillment in accordance with the honor of the Crown. So we say the plaintiffs are entitled to be paid compensation or damages, whatever you'd like to call it, for their lost opportunity to engage in a process by which the parties would have discussed whether the Crown would capture more of the resource rents available to be captured, whether they would treat the amount available for sharing as though additional rents were in fact captured, and whether the share should be 100% or 70% or 90%. Now, the second of those about treating the amount available for sharing as though additional rents were captured, that's the Carney proposal of 1858, and This is now the fourth time I think I've referred to Carney, so I'm just going to give a reference to the Carney letters to Penny Father. You'll find those referenced in my main argument at paragraph 324 and my reply argument at paragraphs 157 and 174 to 177. I do consider, the Carney exchange an important one. So I want to make sure that the court understands that when we talk about the treaty obligation, it's different than the loss resulting from the breach of the obligation.
Sorry, could you finish the sentence?
I did finish it.
Different than,
Oh, sorry. The losses, well, maybe I'll rephrase it. The losses caused as a result of the breach are not the same thing as the treaty obligation. So you have a treaty obligation to share, and then you have a breach of that, and you have a breach of the engagement process. And because the engagement process involved identifying what would be shared, you've got really two elements of the breach, two elements of loss. And so for the future, for example, in the future, if there is an engagement process, then the plaintiffs would not be able to say, absent, I suppose, a court award saying that the engagement process was flawed and didn't lead to anything and was wrong. But if a valid engagement process took place and there was $100 to share, the Anishinaabe couldn't say, we've lost something, we've lost the opportunity to be involved in an engagement process. They couldn't say that. But in the past, it's different. In the past, because of the actions of the Crown, the plaintiffs have lost the opportunity to cause the pie, the shareable portion of the resource rents that could be captured by the Crown. We've lost that opportunity to make the pie bigger. We've lost the opportunity to make the global pie bigger, capture more of the rents. We've lost the opportunity for the Crown to capture more of the portion of the rents that did exist. And we've lost the opportunity to increase the slice of the pie, if you will, that should go to the Anishinaabe. And that is a loss that exists for the past over and above the direct and indirect, which on the evidence we have proven was factually collected.
so, to be possibly unnecessarily argumentative, but let me try this.
Yeah.
So had there been an engagement process, and you suggest that that engagement process might have been within the parameters of increasing the size of the pie, increasing the slice of the pie.
Yes.
Might it not, just because it involved human beings who finally met at the table, might it also not have included what activities the Crown was undertaking?
Yes, it would have.
And possibly might have reduced the size of the pie. They might have said, we don't want mining here.
That is possible. Yes, I acknowledge that, but I don't see any evidence of that.
Well, I don't know that there's evidence on either of where those discussions would have led, except that it would have led to the expression of interest in how the land is used.
Yes. Well, but, and here's where I think onus becomes important, right? I mean, let's use a hypothetical that these engagement discussions took place in 1927, And one of the First Nations consultants said, what do you mean you want to cut down the trees right there? We don't think that's a good idea. If that discussion took place, then the Anishinaabe have nothing to complain about. That's true. I accept that. But there isn't evidence of that. And who had the opportunity to take part in the engagement process? Whose fault is it that there was no engagement process? Who, what, or put it in, I'll try and put it in the positive. The obligation for the plaintiffs in this case is to bring such evidence as was within their ability to bring to establish and prove their case, absent equitable presumptions, okay? They would have to prove to the court's satisfaction on the balance of probabilities that a loss was reasonably suffered. What we have in this case is we have some evidence about what happened in 1858 with Mr. Carney, but we don't have an engagement process at all. Now, we might have had some evidence about what would happen with an engagement process if there had been something that happened between 2018 and 2023. Could have been some evidence for the court.
Well, should one ignore, let's say, the last decade or decade and a half of whether it's decisions from courts or headlines in the paper that engagement processes between the Crown and Indigenous communities have often been aimed at limiting development?
Well, I don't know that that's actually true, and I don't think the court should take judicial notice of that.
I don't, that's what I'm saying. I don't want to take judicial notice of the positive, but should it not be as much assumed that it would do that as increase?
No, I don't think it's fair to take that presumption. I think in the world of possibilities, both are possible. But we have to confine ourselves to realistic contingencies. And could the court say there's a realistic contingency is that there might be some First Nation that says, don't cut those trees? Well, that depends on the evidence laid for that. What was the evidence in this case laid by the Crowns to demonstrate that the Anishinaabe didn't want the trees cut in respect of the resource rents that were taken out? So let's consider the world of all the resource rents from 1850 to 2019, and let's confine ourselves to one company, Abitibi, say, who had licenses to cut trees. Where in the evidence is there evidence of Anishinaabe saying, don't cut down those trees that Abitibi is cutting down? It's not there. And that is evidence that is part of the Crown's defense to say a realistic contingency is you would have said, don't cut down those trees. Now, it might be that the Anishinaabe said, maybe there's evidence that they said, don't cut down the trees in Treaty 9, in the Treaty 9 area. Maybe they said, don't mess with fish but that's not relevant to the issue of the world of resource rents that has been identified by Stiglitz and Hutchings. That world is comprised of, they went through the public accounts and every, all the data. My friends were not adverse to digging into the data to find excerpts of departmental records or the like to try and prove their point. But what they didn't bring is evidence of a negative contingent, what I'd call a negative contingency, for the court to be able to say it's a realistic contingency. So generally, yes, it could happen. But lots of things could happen, but is there a factual foundation to say that it would? And here we have Carney early on, before the treaty promise is forgotten, giving us a factual foundation on which to suggest that things may very well have been different. And it's very, very difficult, I acknowledge it, for the court to sort of put itself in the position of what would, over and above what was captured, what would a crown do properly embracing the honor of the crown and diligent and purposeful fulfillment in a way that, and I want to quote from the judgment on this. In a way that would assist the parties, this is to realize the future opportunities and potentials of the treaty territory in a manner consistent with respect, responsibility, reciprocity, renewal, justice, fairness, liberality, and benevolence. What can the court say about what would a crown so motivated, what would it have done? I think there's evidence that Mr. Carney answered that question in 1858. And we say that ultimately it boils down, ultimately there is evidence that you can rely on to suggest that it would have been something greater than what was collected, which is direct and indirect. How much greater? It's difficult to say. It would have, we say, been something, and could have been, we know the upper bound, of course, is the full suite of resource rents. That's the upper amount. So is it a realistic contingency, positive contingency, to suggest that there would have been greater rents recovered or shareable, or that if the crown chose policy decisions to give subsidies or to not collect the full value of what they should be collecting, that they, like Carney, would say, you know what, we're still going to account or to the Anishinaabe as though we had collected this money, because it's not fair to do this to our treaty partner who is relying on us to be fair and honorable.
So is your reference to the Carney approach simply maximization of the revenues from the activities that did occur, the resource extraction activities that did occur?
No, well, in practical terms, yes, because we are limiting our claim to what was actually recovered. I could make the argument that we could have been claiming not 126 billion, but 136 billion, because maybe they could have extracted more. That's not what our case is about. Carney's analysis would suggest that one could go that far, but we're not in this case. Call that a conservative element of our claim.
And Professor Stiglitz made that point.
Yes.
He's not talking about cutting more trees.
That's right. A point that wasn't lost on Professor Bodway, who said, look, if you really, really want to know what the value of the territory is that the Anishinaabe, sorry, he didn't link it to what the Anishinaabe brought to the table. He just said the value of the territory. You should be looking at the optimal, not what was actually brought in, but the optimal, what could have been brought in. So to the extent that that has any bearing on the subject, you can take that into account. But the important point I was trying to get at here is that the loss is different than the value of the trees.
Is, when you say is different, it's more than,
More than.
okay. Because you don't,
In this case, it's more than, and it's also different, actually, because you're compensating for something different.
bigger lots.
Right. And in a world where an engagement process took place, how could we sue for the loss of opportunity to engage in a process? So it's really, I mean, I would hope that after your judgment, there is engagement processes in the future that prevent us from suing for a breach of the engagement process. I hope that happens. But for the past, it didn't happen, and the Crowns have only themselves to blame for that. And to say to the court, as they do, that there can be no losses for that lost engagement process is wrong. It's wrong in law and it's wrong in principle. And if the court were to accede to it, it would be as much as saying that the court is rewarding them for their delay in choosing to engage in a process, because for each year that they don't engage in that process, they're rewarded by not having to pay anything. That can't be justice. That can't be right. The Crowns raise other defenses as well about it's really just bringing in fiduciary duty through the back door, but we'll get to that later. It's not. So if I've made my point here is to make sure the court got my point on this issue of what the loss is. And having done that, I'm going to move on to considerations to be taken into account in fashioning a just award. Now, I cover this rather extensively in my main argument at part 3, and also in part E as in Edward of our reply. I do not plan to go through this part of my written submissions in detail, but much of it, while important, I think is I hope uncontroversial. So while I'm going to mention what I consider to be relevant criteria, or some relevant criteria that guide the court, most of my oral presentation on this topic is going to focus on the areas that I perceive to be of significant areas of dispute. So I wanted to start with the guidance of the Court of Appeal and the amended judgment. And so this is part of my argument at paragraphs 133 to 147 of my main argument. And I've made myself some notes. So there are key takeaways from the reasons and the judgment. Key takeaways I want the court to remember in deciding this case are: the augmentation promise is a collective entitlement. Secondly, the judgment requires a matching exercise. Only expenses that relate to collecting, regulating, and supporting relevant revenues matter. Not any expenses that support resource rents, but resource revenues. Third, the judgment does not confine the relevant revenues related receipt, the relevant Crown revenue related receipts to those captured directly by the Crown through an NCRR calculation. Those captured directly are obviously by definition used by the experts, the NCRRs. But on top of that, the Crown captures other resource-related revenues through indirect means, and we've discussed that already. 4, the common intention of the treaty parties is to allow both the Anishinaabe and the Crown to realize the future opportunities and future potential of the treaty territory. So from a view of 1850, it is a forward-looking agreement. It is one where the engagement process will help define what the future opportunities and future potential of the treaty territory is. And we pause here for a moment to observe that if it's true, as Ontario argues, that it is not the Crown referred to in the treaty, and Ontario is but a stranger to the treaty, then in determining the quantum of the augmentation from time to time, the court must not weigh or consider what share of the productions from the treaty territory Ontario would receive. I want to think about that for a moment. If the treaty, is for the purpose of allowing the treaty parties to share, and if Ontario is not a treaty party, then the court doesn't need to be concerned with the Crown, Ontario's share of the wealth from Ontario's resources. And you're looking at me like that makes no sense. And I'm saying, no, it doesn't make sense. And it's proof as to why Ontario is a party to this treaty. Because it would be ludicrous to suggest that one need not take into account Ontario getting anything from its own resources. So we do not advocate that Ontario is not a party to the treaty, but what we have tried to describe is the logical outcome of Ontario's proposition that they are a stranger to the treaty. The next major principle that helps guide the court to a just award is the way in which the opportunities and potential into the future, looking from 1850 forward, is to be shared. And that is in a manner consistent with respect, responsibility, reciprocity, renewal, Crown honor, justice or fairness, liberality, or benevolence. That's right in the judgment. I observe and note that these principles simply did not factor into the Crown's calculations of past amounts owing. But some of these principles are now invoked by the Crowns for the purposes of asking the court to avoid providing any binding guidance for the future. Six, there is a treaty right to an engagement process. Discuss this at 3.2.3 of my main argument, at paragraph 140 and following. Now, I don't know if this is a subtle point or not, but the treaty right to an engagement process is not a Section 35 consultation right. It is a treaty right embedded within the treaty. It's a promise to engage in a process. 7, the identified purpose of the engagement process is to determine 1, the amount of net Crown resource-based revenues. That's paragraph 1B, Roman numeral 1 of the judgment. And if you want to follow along, it's at tab 2, The judgment is at tab 2 of my compendium. Secondly, the identified purpose of the engagement process, the second reason for it is to seek agreement on the amount of net Crown resource-based revenues to be dispersed pursuant to the augmentation clause. And that's a combination reading of sections 3A and 3C of the judgment. The third thing that the engagement process is geared to do is at 1E. To consult in accordance with the honor of the Crown to determine what portion of the augmented annuity is to be dispersed to individuals. That is where the Crown's discretion lies in the third item. That is the clause to which the graciousness clause applies. Importantly, if you look at, and we're getting on to the next point, paragraph 1B, Roman numeral 2. If there is an agreement on the quantum, the Crown must pay it to the Anishinaabe. It doesn't say that they are to place it in the band trust accounts. It doesn't say that they are only to allow the interest to be used and to create some sort of Fidel Anderson annuity. It doesn't say that the Crown is a trustee or a fiduciary who has to invest it for the First Nations. It says they must pay it. If you couple that with the requirement of diligent implementation of treaty rights, that would require the augmentation to be paid in a timely manner, i.e., when due. Importantly, if there is no agreement on the quantum to be paid by way of the augmented annuity, then the principles to be applied, for the purpose of determining the amounts and the determination of the amounts are for the court to decide upon. This is what the judgment says. And the principles to be applied are there. I just referenced, look at paragraph 3C of the judgment. And the determination of the amount deemed for the court is paragraph 3A. The Crown's vision, so 3C and 3A. If there is no agreement, then the court determines the principles and the court determines the amount. This is important because there's a misplaced notion in the Crown's minds, if I might say, that the Crown is the arbiter of form, level, and aim. That is not what the reason said, and that is not what the judgment says. The judgment says it is the job of the court to do this. The Crown's vision is that the court, the guardians of the Constitution and the protectors of the rights enshrined therein, have no role in deciding on the correct quantum to be paid. For the Crown's, the court's role is limited to judicial review of the Crown's decision. Ontario, it seems, would further limit the nature of the judicial review to an administrative law test of reasonableness. And what I can gather from Canada's argument is they are prepared to admit that the honor of the Crown has a role to play, but this position still leaves the Crown with discretion to decide on the amount of the augmentation when the reasons and the judgment say otherwise. And it makes sense that the court is the arbiter of this. The court is best placed to decide with an even hand on the proper quantum in the event of disagreement. Remember that the treaty talks about productions from the treaty territory. Let's just look at those exact words at tab 3. I've just got an excerpt of the treaty. The said William, this is at page 13 of the compendium, tab 3, second paragraph. The said William Benjamin Robinson, on behalf of Her Majesty, who desires to deal liberally and justly with all her subjects, further promises and agrees that in case the territory hereby ceded by the parties of the second part, that's the First Nations, shall at any future period produce an amount. So there's an objective element here of the territory producing an amount which will enable the government to pay without incurring loss, to increase the annuity, thereby secure to them, then, and in that case, the same shall be augmented from time to time. So the productions from the treaty territory on a wait and see approach are, as Stiglitz and Hutchings identified, a matter of objective fact. It's not a subject of debate. It's a subject of opinion about whether their estimation is correct. But resource rents exist regardless of who collects them. Productions from the territory exist whether the Crown collects them or not. So the court is in the best position if the question arises, well, what are the productions from the territory? And the answer is an objective, they are the resource rents on a wait and see approach. That's what they are. Now, the separate question of, well, can the government pay them without incurring losses is another question, but another issue. We'll get to that. But the court can identify, I think the evidence fairly said that the best you can do is estimate what the resource rents is. There isn't an exact mathematical proof as to what the resource rents are. Admittedly, if you keep proper data, you might be able to get closer and closer to the actual. But in the past, because records weren't kept, the best we can do for the past is an estimate. But that's not the plaintiff's fault. Now,
A question that has
yeah,
started to trouble me is the notion of this term annuity. You say the treaty promise is a promise to pay a share of the properly calculated productions, let's say,
yeah,
rising from the productions when due. Right? So in the
Yes.
year that they're due or the year after they're due, something like that.
yeah.
So that wouldn't necessarily be an annuity then. Is that why perhaps this whole exercise of risk adjusted came up? Was it some understanding that at some point someone had to figure out what a fixed annuity would be? And so looking forward, they had to presume that there was X amount of income and then take all risks into account because they were going to pay the same amount every year?
No, that doesn't necessarily follow, because an annuity doesn't have to be the same amount An annuity can be, you can buy a variable rate annuity that pays different amounts each year, depending on the rate of return you get.
Depending on the rate of return and presumably depending on whether there are additions or not to the capital on deposit.
Right. I mean, those could all be variables, but the point is that what we have in the reference to annuity is a payment that is being made yearly. And I suggest that it would be doing an injustice to the case to pretend that what was expected was not some sort of annual payment. They even identify, unlike in the Huron Treaty, where the time of year is not identified. In the Superior Treaty, they say on or before, I think it's August 1st of each year. I don't have the exact treaty in front of me. It's August 1st or August 15th.
So just for the purposes of definition, you say the single element that defines an annuity is that it's paid annually.
Yeah.
Not that it's some reference to some fixed amount.
That's correct. That would be my understanding of how the Anishinaabe also conceived of it, as did the Crown. Each year it could be different. And in fact, as divided up between the those Anishinaabe between 1850 and 1875, it was different every year.
Well, it was distributed differently.
It was distributed differently, but the 500,
the payment, the annuity payment,
you're right,
to the collective annuity payment, which was the only
right
annuity payment.
But let's say that there was enough money that came in by 1857, as I think the evidence showed at trial, that the Robinson Superior annuity could have been augmented. Now, how much would it have been augmented? Let's suppose it would have been augmented by a further 500 pounds. So that the annuity for that year would have been 1,000 pounds. Now, the next year, maybe revenues went down and there was only enough to give 500 pounds. Remember, 500 is the floor, right? But just because it isn't a fixed amount doesn't stop it from being an annual payment, an annuity.
As part of your answer earlier, you said that's how both the Anishinaabe and the Crown understood it. But when the Crown was capitalizing their annuity obligations, they presumed it was, well, maybe that's because they were fixed on the $4.
Yeah, I think it's fair to say that at least the bean counters that decided to fix the annuity did it on the basis of this idea that it was capped at, that it was a $4 fixed amount. I mean, what's a little bit odd about it, as was revealed in the evidence of sorry. Eric Angel, excuse me. What was a little bit odd about it was that I think it was what was it? It was in was it 1893 or 1900 or something, 1903, when at the very end they end up figuring out, aha, based on our calculations, there's extra money available to augment on the Huron side, and then they divide it up between they capitalize it by giving a portion to Superior and a portion to Huron on the same percentages that the populations were in 1850. I mean, that was a little bit of an oddity that seems to belie the idea that it was something fixed, because from their perspective, well, I think wrong, but from their perspective, there was nothing that should have been put into or capitalized for the Superior side. But they did.
Because they were showing no revenue.
Right. Well, no, sorry. Not according to Mr. Hutchings, but according to Canada, Ontario.
Yes. They those crowns.
Yes. So I was getting to say that the portion of the resource rents that the Crown should and could reasonably include for the purpose of the augmentation calculation in order to secure the purpose of the treaty promise is likewise a matter that is best left for the court. Now, I very decidedly said should and could reasonably include for the purpose of the augmentation calculation, because I see the augmentation calculation as something different than trying to suggest that the court has any business telling Ontario or Canada, this is how you must utilize the resources. It might be wise for Ontario and Canada to engage in co-management with the Anishinaabe. It might be the right thing morally to do, and it might be sensible for them to do it. But as a function of your order that we are asking for, we are not asking you to compel the Crown to give up its jurisdiction over natural resources. What we are saying is, if the Crown wants to make policy, that your decision could reflect and should reflect that if policy decisions are made that are made in a manner that doesn't benefit or is not in the interests of the Anishinaabe to which they disagree, then the court should be able to decide whether that action of the Crown is not only just reasonable, but whether it can be justified. And we're going to get to breach and justification later. The court, and not the Crown, is the appropriate decision maker to decide what portion of the Crown revenues should be paid to the Anishinaabe in fulfillment of the treaty promise. If it is otherwise, then to speak of a treaty right to an augmentation on the happening of certain events becomes little more than a right to be consulted about what the Crown thinks is appropriate. And here, it would be without the Crown having any fiduciary obligation to advert to the best interests of the Anishinaabe, because there is no fiduciary duty. That, with respect, is a recipe for disaster and puts reconciliation at but a distant hope.
Let me see if I get that. You say that the plaintiff's claim is not that the court order co-management or joint decision-making.
That's correct. We do not ask for that.
But that, and I don't think you used the word justification. I was just looking for it. But
I did at some point in the last 5 minutes.
Oh, okay.
But it's for the court.
Yes, yeah. But you do say that if there is a complaint that the Crown has made policy decisions that prejudice the Anishinaabe, that the court is the arbiter of that decision. And that justification question then goes to the court.
Right. Well, assuming the plaintiffs could prove breach, right? I mean, we'd have to prove a prima facie infringement before the justification comes up. I guess that would be a burden on the plaintiffs. But if that's proven, then there's justification. And who knows? Maybe the Crown brings evidence to the court's satisfaction that, we couldn't increase the annuity from railways. Let's suppose they wanted to throw in, I don't know, maybe I'll use trees. Let's use trees. We couldn't include in the revenues, as you suggest, First Nation. You said we should include in the stumpage fee, but those trees had been damaged and there was an overriding concern that they needed to be cut down right away, and we couldn't find anyone. And the court says, well, here's a good reason why you couldn't increase the revenues, right? So again, there'd have to be, I would think, some sort of rational connection to the treaty. And there's been a fair bit written in Sparrow and following about justification would help the court in the future identify, is this prima facie breach justifiable such that the First Nation doesn't have a claim?
Do I put it correctly if I say that your proposition is that the court is the appropriate decision maker where claims of a breach are defended with an assertion of a policy basis and the plaintiffs demand justification? Maybe I've missed the step. The court has found a prima facie breach.
Right. The court has to find a prima facie breach before there's justification. But the policy choices are for the Crown to make, but the effect of the policy choice has implications on the treaty. There's a treaty right to take part in an engagement process to discuss what the revenues should be. And if the Crown says, we have heard you, we disagree with you, we are going to make a decision not to increase the revenues as you suggest, the First Nation should be entitled to say to the court, that's a wrong decision. They can have their policy decision, but they can't do it at our cost. So
the justification has to be related to the.
And if they can justify, the Supreme Court of Canada has long ago conceived of the idea that if the Crown can justify infringements are okay. We're not suggesting that the court say there can never be an infringement of the treaty. We are saying that any infringement has to be justified in accordance with the law. And that's the role for the courts. It's not the role for the Crown to be judge, jury, and executioner. We're talking about rights enshrined in the Constitution. We can't, I'm imploring the Crown, the court, excuse me. I implored the Crown to no avail, but I'm imploring the court not to turn this treaty right into a right of consultation to which there's only judicial review. It's not a Section 35 consultation right, it's a treaty right. Continuing on, with considerations to be taken into account in order to fashion a just award, I wanted to discuss at page 43 a couple of other factors, and I'm just going to, I think, maybe read from the or take my cue from my headings. At
Page 43 of the compendium?
And no, I'm at page 43 of my closing submissions, main closing submissions, paragraph 205.
Just getting there.
Yeah. Thank you. My apologies. So at section 3.5, paragraph 205, we're talking in the argument about ensuring the Crowns are not rewarded for 170 years of neglect. I guess it's maybe closer to 173 or 174 now. The plaintiffs acknowledge that a monetary award must be reasonable to both parties. But this court, it would be mistaken if the award otherwise properly owing should not be paid because the amount is large. I know there's perhaps, I don't know if it's a trepidation or a reality check. I've heard people say, but it's so much money. Respectfully, visiting upon the Crowns the consequences of their choices over the last 173 years is just. Under no guise should the Crowns be able to benefit from the wrongful conduct. The words of Justice Dixon, as he then was in Thornton, are instructive. He wrote at paragraph 20, "It is an error in law to regard the ability of the defendant to pay as a relevant consideration in the assessment of pecuniary damages. The correct principle is proper compensation for the injuries suffered by the victim. The exact amount in any particular case must be determined from the evidence presented by the parties at trial. Fairness to the defendant is achieved not by a reduction for ability to pay or by an arbitrary slashing of the award, but by ensuring that the plaintiff's claims are legitimate and justifiable. The effect of applying a proper bring forward calculation is not unreasonably visited upon the defendant Crowns who have ignored the treaty bargain for over 170 years and who continue to refuse to abide by the outstanding judgment." Article 3.6, some lessons to be learned from Southwind. And here it's interesting, Canada, I think, is with me on this, on much of Southwind. My position is that that Southwind gives us a roadmap, if you will, on how to fashion a just award and the elements that you should focus on in giving a just award. Now, as far as I know, I don't think there's been any case that's really grappled with the issue of what are the proper principles of compensation for breach of a treaty. There's discussion of cases in equity, discussion of cases at common law. There's discussion of why the two should not be different, why they should be different. But there isn't a case that I could find that says this is how you deal with a sui generis treaty right. And so when I looked at Southwind, although I concede it is a case in equity dealing with fiduciary duty, the principles drawn by the court, if I can summarize it like this, in Southwind, the court acknowledges that there is an equitable claim before it, breach of fiduciary duty, but doesn't simply say automatically all the presumptions in equity work in favor of the First Nation. They took a more nuanced approach, and their nuanced approach helps identify for this court how to craft a proper remedy for breach of treaty. It's 4:25, and now that would be a good cliffhanger. That's about as best as I can get. Would it be okay, or do you want me to just continue on for 5 minutes?
5 minutes, sure, go ahead.
Okay, sure. Okay. I'll stop in the middle. Okay. So let's take a look, and I talk about this at paragraph 208 and 209. In Southwind, the Supreme Court of Canada discussed there are different policy rationales supporting the remedial approach to common law damages as opposed to equitable compensation, and that those differences help explain why remedial approaches to the two are different. Well, you can say the same thing about, what about the sui generis treaty right? So it's important when crafting an appropriate award in this case to appreciate the principles considerations discussed in Southwind should apply equally to breach of treaty. Not necessarily the conclusions, but the principles. So let's take a look at what the majority, Justice Katsanis, said when she wrote, in concurring reasons in Canson, McLaughlin J. stressed the differences between equitable remedies and common law damages, explaining that the purpose of equity is to enforce the trust which lies at its heart. Analogy with common law damages may not be appropriate given the misalignment between the purpose of fiduciary obligations and obligations through tort and contract. Then refers to Lord Reed from another case where he said, in negligence and contract, the parties were taken to be independent and equal actors, concerned primarily with their own self-interest. And I'm going to pause there because that characterization of independent equal actors concerned primarily with their own self-interest does not sound very much like the relational treaty agreement that the parties developed in 1850. Court goes on to say at paragraph 72, another difference between equitable compensation and common law damages is that equity is especially concerned with deterring wrongful conduct. Yes, it says by fiduciaries, but the emphasis is they want to deter wrongful conduct. But why do they want to deter wrongful conduct? As Professor Rotman observed, beneficiaries are implicitly dependent and particularly vulnerable to their fiduciaries' use, misuse, or abuse of power over their interests. It is therefore crucial that equitable remedies deter fiduciaries from misusing their powers. By restoring the beneficiary's lost opportunity, equitable compensation enforces the fiduciary relationship and deters wrongful conduct. So what's enforcing is the fiduciary relationship. Now, I emphasize that even though there's no fiduciary duty here, there remains a fiduciary relationship, and you want to deter wrongful conduct, and you would want to deter wrongful conduct in a treaty breach case because of the honor of the crown. Paragraph 73, due to these differences, rather than relying on common law principle, McLaughlin explained that the proper approach to equitable compensation is to look to the policy behind compensation for breach of fiduciary duty and determine what remedies will best further that policy. And I think that this is instructive for this case, because what I think this court should do for a sui generis fiduciary duty is to look to the policy behind compensation and determine what remedies are going to further the policy behind compensation for breach of treaty. McLaughlin goes on to say, the court goes on to say, and this is the bolded part in paragraph 73, the rules appropriate to a breach of duty by a trustee have to be determined in light of the characteristics of the obligation in question. And here too, what we have to look to is what are the characteristics of a treaty obligation? So the constitutionally entrenched Robinson Superior Treaty is unlike a one-time arm's length commercial transaction of independent equal actors concerned primarily with their own self-interest. So what we say is that there is a list of considerations concerning treaty rights that should guide the court in search of a just and appropriate award in this case. And those are listed at paragraph 212 of my argument. And I will list them before I break. 1, the proper remedy, not the cause of action, properly guides the inquiry. 2, the unique or sui generis nature of the treaty right in general need to be considered. 3, the goals of the specific treaty promise at issue need to be considered. What does the treaty seek to achieve? What is the purpose behind the promise? 4, what is the nature and importance of the treaty relationship that an award is intended to foster? 5, how does the court deal with the importance of both deterring future breach and encouraging diligent implementation in the future? Because diligent implementation is really the flip side of the coin of deterring future breach. And 6, constitutional provisions. How does the honor of the crown and reconciliation factor? Each of these factors are to be discussed when we return. Same bat time, same bat channel.
Okay.
Yes. Okay, my colleague has mentioned that I made an error in the transcript at 1628:32. I made a reference to sui generis fiduciary duty. I was, of course, referring to the sui generis fiduciary relationship in the treaty context. I do not mean to speak of fiduciary duty, but fiduciary relationship. So thank you for that correction.
Thank you. All right, let's break for the day. And we'll resume at 10 tomorrow. I would like to meet with you briefly, and I'm just figuring out here where we do that. I believe there's some room close by, but I'll tell you tomorrow morning, and it's nothing you need to prepare for. I'll try and do it before we break for lunch or after lunch. Okay. Unless there's anything else.
Nope.
We're done. Okay, thank you.
Order, all right.
This court stands adjourned until September 12th, 2023 at 10 a.m.